Well, let's follow up on the significance of today's Supreme Court ruling on abandoned oil wells. Barry Robinson is a lawyer with Ecojustice. He joins me from Calgary. His organization was an intervener at the Supreme Court on this case. Mr. Robinson, first of all, thanks for setting aside some time to discuss the Supreme Court ruling today. It's good to see you.
Yeah, my pleasure.
Look, before we get into the nuts and bolts of what happened today, can I get you to give us a little bit, a short synopsis of how this legal battle began?
Yes, this was a situation where an oil and gas company that had about 127 properties went bankrupt. And when those properties went into the hands of the bankruptcy trustee, the trustee interpreted the Bankruptcy Act as they saw it. And what they did is they said, we will keep the 20 or so still producing and profitable properties, and we will renounce or disclaim the 100 or so properties that are not producing and are not of value and just have cleanup costs left. And so they attempted to do that. Then the Alberta Energy Regulator stepped in and said, well, no, we have some environmental orders to have those properties cleaned up that we want you to meet first. And this led to the debate before the court on what came first, in first priority, the environmental orders or the ability of the trustee to renounce or disclaim the properties that weren't producing.
Right, and to be clear, two lower courts sided with the receiver and the trustees on this until we got to the Supreme Court today. Well, so what does today's ruling change?
Well, today's ruling is a good ruling. It clarified a very confusing area of the bankruptcy law. And what it said is it said to the trustee that, no, you cannot just totally renounce these properties and ignore the environmental orders. It made it clear that the trustee was not personally liable. That is, they didn't have to use any of their own finances to follow those orders and do the cleanup. But it said you do have to use whatever assets you're holding from the bankrupt company to obey these orders and do the cleanup.
So is it fair to say, simply put, they've now put environmental interests ahead of the financial interests of the creditors? So cleaning things up comes before paying people out. Is that it?
Well, I think in a nutshell, that's close. It'll depend on the facts of each situation. But what the court said is that when a regulator like the Alberta Energy Regulator is acting in the public interest and putting out environmental orders that are in the public interest to have land cleaned up, they are not just a creditor who has to get in line behind other creditors, that actually, for those environmental orders in the public interest, take precedence. And that's a good thing for the environment.
How big is this problem? How many abandoned wells are we talking about in the province of Alberta?
Well, right now there's about 89,000 inactive wells in the province. Now, there's some good reasons for some wells to be inactive. To me, the real problems are ones that have been inactive for a long time. So if we have over 28,000 wells that have been inactive for more than 10 years, and the regulator themselves say less than 1% of those wells will come back into production. So that's the nature of the problem. The regulator says that the outstanding liability on wells is about $30 billion. And the regulator only holds about $235 million in security at this point.
Okay, so if the bankrupt companies and the receivers who are taking them over have not been compelled to clean up those wells with whatever assets are left, who's been cleaning them up?
Well, they've been going to the Orphan Well Association, but that's become a problem in that 5 years ago, the Orphan Well Association had about 175 properties in their queue. Now they've got over 3,000. So now we're looking at decades before these properties are cleaned up. And that's why we've been saying for a number of years now, the real solution here is that the regulator should be collecting security up front on the day the well is drilled for the final cleanup. And that would avoid all these problems. The company goes bankrupt or disappears, the regulator would be holding the funds to do the cleanup. It would be a good incentive for companies to go in and do the cleanup and get their security back. And I think it would even be of value to the banks that are lending to these companies. I know in this situation, rather than having all the assets of the company now going to the cleanup, the bank could have recovered probably $4 million out of their $5 million loan.
Right. I mean, is there any guarantee that bankrupt oil and gas companies will even have the assets left to allow bankruptcy trustees to pay the cost of cleaning these orphaned well sites?
Well, that's the problem. By the time many of these companies go bankrupt, they're empty shells. So even if the environment has priority and the environmental order has priority, it's quite likely in many cases that there just won't be enough dollars in the hands of the bankruptcy trustee to carry out the necessary cleanup work. And that's why we think it's essential that the regulator hold that money up front.
All right, you've talked about having the companies put this money up front to allow for a cleanup of abandoned wells if they do run into financial problems. I guess if you look at the front end of that, is what could this mean for the smaller oil and gas companies and their ability to get loans from banks if those banks now know there's this increased liability if the companies fail?
Well, I think that's a very interesting question, is how the banks are going to react to this. Obviously, they are, I think, going to be looking for more security. So they might do the job that the regulator has not done, and that may be that they start asking, particularly these smaller companies that look vulnerable, they may be asking them to post security for any environmental costs up front before they consider loaning money to them.
Do you think there's wider implications for this Supreme Court ruling? It's the last stop in the legal process to other issues such as this about where there's a trade-off that involves remediation for the environment in some of these projects. Do you think there are other implications for the ruling today?
Yes, absolutely. This ruling will apply in other industrial settings wherever a company has left behind contaminated land when they've gone bankrupt, and some party, in many cases the government, has to step in to do the work. So this will have a wider application for sure. And I think it's going to depend on the facts of each situation, and the court was clear about that. But I think generally it's going to be good for the environment and good for making polluters responsible for their cleanup.
Barry Robinson from Ecojustice, thanks for your time today. Good to speak with you.
My pleasure. Thank you.